Hi, everybody. This is Arkady Frekhtman, a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. And today we are coming to you live from our beautiful office here in Brooklyn, New York, Bensonhurst. And so if anyone's out there watching, feel free to leave your questions and we could read them live and answer them live right now. So meanwhile, what I'm going to do, if we don't have any questions yet, what I'm going to do is I'm going to go to the comments in the channel and maybe start with some prior questions that we had, either this week or the prior week. So let me take a look here. I opened up the live chat and I'm going to go to the comments. So here's a question from Reginald Williams. It was asked about 3 hours ago. And he asked, what is considered low property damage? Is it $1,500 and below? And he was responding to a short video we did entitled Dealing with Low Property Damage, where I talked about one of the ways that attorneys deal with low property damage. Because, if you bring a lawsuit and you're in court, one of the issues you could have is that the defense lawyer is going to say, well, there's not a lot of visible property damage. And if there's not a lot of visible property damage, then you couldn't have been hurt. And so I gave the example of a chair that, let's say, for example, I'm sitting in a chair and somebody comes running really hard and kicks the back of my chair and then, hits me so hard that I'm fall out of the chair onto the ground. And I'm like, oh my God, my back really hurts. Would it be fair to then for the person to turn around and look at the back of the chair and say, look at the back of the chair. There's no damage to the chair. The chair looks fine. So you could not have been hurt. And it's not really fair. And you do that demonstration for the jury at trial. And also in the same way, you could do it with a carton of eggs. Like, for example, when you go to the supermarket and you get a carton of eggs, why do people open the carton and check to make sure the eggs aren't broken? Well, they do it because you could damage the egg inside the carton, even though the carton itself is in great shape. It's not damaged, right? So it's the same kind of theory. But to answer his question, he was asking, well, why, the property damage? I mean, in my mind, it's not really a number. Like usually, if it's under $1,000, that could be low property damage. Under $1,000 is kind of considered low. Usually, low property damage really. That phrase, not a lot of visible property damage. What that really means is there's a scratch, right? Or there's nothing, or there's a little bit of a scratch or a scrape and nothing more, maybe a scuff. That's really a problem for a plaintiff's lawyer. If you have bent metal or crushed metal or any kind of damage that will require a repair of a few $1,000s, you're okay, because the lawyer could get up in opening statement, let's say, and he could say to the jury, if this crash was bad enough to bend the metal on my client's car, just imagine what it did to my client's back, right? And that's all you need to do. So if you have bent metal, you're in good shape. So I would say anything under $1,000, scratch or scrape, that's considered low property damage. But that short was just one of the ways to deal with it. Okay. Let's see, what other questions do we have? We have another question here also from, oh no, this is a different question from Ray. The first one was from Reginald. This one is, can I ask you a straightforward question? How long does it take to get the insurance policy after you filed a lawsuit? And is there a reason why it would take so long? Can you please answer? I'm making my decision on things. So yeah, I mean, usually from the time that you file the lawsuit to get the insurance policy, it would usually take about, I would say, I mean, in New York, I would say about a month, maybe 2 months, because you have to file the lawsuit. You have to give the defendants about 30 days to appear in the case. Once they appear in the case, you file for what's known as a preliminary conference with the court. And now there's a new rule. So in the preliminary conference order, automatically, they're going to tell you the insurance. Now, if they don't tell you, or if they don't tell you all of it, you could send them a demand, which is just a piece of paper or request, and you say, give me all the insurance that you've got, give me the excess, the supplemental, the concurrent, the umbrella, give me all of the insurances. And then if they don't give it to you, you could file and the court will issue a court order forcing them. So it could take a little bit longer, but usually, like I was saying, it usually takes about about 2 months or something like that. Okay, let's see. And then we have, here's a live question we got. I think this is the first live question from an Abeba. And here she says, "Hi, attorney. My lawyer sent a demand letter, and now 3 months the insurance has not responded. It's a slip and fall case, and I have post-concussion syndrome. What value is my injury?" Yeah, I mean, I'm sorry to hear that. Post-concussion syndrome, what I would recommend is to get it worked up with a neurologist, and also perhaps if your lawyer and your doctor feels you need it, a full workup with a neurologist, a neuroradiologist, and then they can do certain imaging like a PET scan, a 3T MRI, perhaps a diffuse tensor imaging, a DTI, or depending on the type of brain injury, they might send you to a neuropsychologist. But really, that's what most of the doctors that specialize in traumatic brain injury, that's what they're doing right now. They're doing the neuroradiology component of it. That is almost like when you have a herniated disc, right, or a back injury. You don't know it's a herniated disc, so you go to the doctor refers you for the MRI. The MRI is the scan, the radiological scan. They hold it up, they're called shadow doctors. So they look at the films and they say, look, I see in the film, that's the herniation right there. So it's the same thing with the brain. With the brain, you do neuroradiology, and they have different scans, and they'll choose the scan based on your symptoms and the doctor's expertise. But there's susceptibility weighted imaging, SWI, there's DTI, there's arterial spin labeling, there's PET scans, 3T MRIs. There's some new tests. I heard now that they could actually test through a blood test, they could find markers in the blood. And if you have certain proteins, that may mean that you're more susceptible to having a traumatic brain injury. So to really get that worked up, that's probably the best thing to do. Now, you said that your lawyer sent a demand letter and it's been 3 months and the insurance company has not responded. I don't know. I'd have to see the letter, the type of letter that he crafted. If he just sent a general demand letter without any conditions or without any time limits, they might never respond, right? What I like to do is I like to send them, I've talked about this in other videos. I like to send them a letter. I don't like to call it a demand letter. I like to call it a settlement opportunity letter. I say, look, this is your opportunity to resolve this case for a fair number. So whatever number he put in the letter, I give them 30 days. And I say, that's the deadline. I actually put the deadline. I'll say the deadline is April 21st, Friday, April 21st, 2023 at 5 p.m. Eastern Standard Time. At 5:01, let's say I put in the letter, it's $500,000 that I'm looking for. That's the opportunity to resolve this case for $500,000. At 5:01, it's gone, right? That's it. The opportunity, the 30 days has passed. At 5:01 p.m., the opportunity is gone. Now it's going to be $1 million. And that gets them upset, right? They're like, oh my God, what's going on? They get scared. And then they either pay the 500, maybe they offer something close, like 350, 375, where you could come down a little and settle it. Or if they're not going to pay, if they're like, oh no, this isn't worth anywhere near 500, we're not going to, make any offer. Then what happens is they just say, oh my God, let's see, which lawyer do we have on this case? Maybe this lawyer that we hired as the insurance company is not the best lawyer. So what they'll do is they'll fire that lawyer and they'll hire a completely new law firm to defend the landlord or the defendant, whoever we're suing. And so whenever I do these letters, something always happens. It just stirs things up. Something always happens. Either they pay up or they offer a good, reasonable settlement close to the number in my opportunity letter. Or they, say, look, here's a good faith offer, let's go to mediation. Or they fire their lawyer and get a new lawyer. Sometimes the lawyer will call me all upset, like, why are you sending me these letters? What's going on? But it just blows their mind. So I love it. Because, it gives us power. Because ultimately, the way the insurance companies do business is they say, look, we are these strong, powerful, insurance companies, and you're this lowly victim, and you are asking us for money, saying that we did something wrong. you're a liar, a cheater, and a fraud. We're not going to pay you anything. What are you demanding? What are you asking for? Are you asking for 100,000? Why don't you demand less? Why don't you demand 50,000? And then maybe I'll give you 20 if you're lucky. You know what I mean? That's their mentality. So this letter, what it does is it flips it upside down and it says, no, I have a case of merit. I have an actual injury victim. This is a civil justice case. Pay me X. If not, then fine. No pressure. You don't have to. I'm not gonna, I can't force you to pay me, right? I can't come there and beat you up. But if you're not going to pay me, then this number that is out there right now is going to be gone forever. And what we're going to do is we're just going to go to trial. And then at trial, the minimum amount that I'm going to ask the jury is not going to be this number, this 500. It's going to be at least $1 million, maybe even more than that. So, guide yourself accordingly. And then they get scared. So it's a good tactic. I like it. It's really worked. Okay, let's see what other questions we have. We have a question here from Nate the Great. I have a case, construction in BK. I don't know if that means Brooklyn, maybe Brooklyn, from 2019. We recently won summary judgment on 241 and res ipsa loquitur. Currently, we're on the trial calendar. The policy is $1 million. I had surgery on my knee and shoulder, both with a soft tissue tear. In this case, we should be able to ask the insurance company to tender the policy. Yeah, I mean, I think so, definitely. You should definitely be able to ask them to tender the policy. If you have a construction accident, New York really protects the construction worker, so that's very good. So if you have a 241 case, that means it's height related, elevation related. Either you fell either from like a ladder, a scaffold, it could be a hole in the floor while the construction was going on. The worker has to fall, right? Or an object that's being hoisted or secured, that's part of the construction, can fall on the worker and injure the worker. So it could be a falling worker case or a falling object case. And those you get summary judgment on liability, meaning the only question is the amount of damages to pay you for all of your injuries, all of your harms, all of your losses. So that's a very, very strong case. And I think if you had a shoulder surgery and a knee surgery, you had both of them, I think, yeah, you should ask for the $1 million and you should probably get it. But I would be surprised if in a construction case like that, the only policy is $1 million. Usually, if it's a construction case, you can sue the landlord as well as the general contractor. They're liable under the labor law. Sometimes you could sue other defendants as well. So make sure your lawyer does their due diligence and looks at all of the potential, avenues of compensation, because I would be surprised if it's only $1 million. It should be more than that, the total insurance. But if it's only $1 million, yeah, I think you should be able to get the full $1 million. And Brooklyn is a good venue for these cases as well. So good luck to you. No, I think that's a good case. Okay, let's see what other questions we have here. We have Good Scout. He says, great channel. I always learn a lot here. Thanks, Arkady. Oh, thank you so much. Thank you. Oh, and Nate the Great writes, the roof caved in. Yeah, well, if the roof caved in, that's obviously gravity related. And by the way, when he mentioned res ipsa loquitur, I don't know if everybody understands what that is. That's a Latin phrase. What that basically means is the thing speaks for itself. That's how you translate it from the Latin. But what it means in terms of the law is that this would not have happened if it wasn't for negligence, that this cannot happen without negligence. So if there's a case like that where the roof just caves in and they're doing construction and they get hit by the roof, they don't necessarily have to go and prove, why the roof caved in, how the roof caved in. If the defendant had exclusive control over the property, then the thing speaks for itself, and this cannot have happened without negligence. Just the happening of the incident means that they were negligent. So those are strong cases. I've had some res ipsa loquitur cases. There's a few different, legal prongs. I believe 3 different legal prongs that you have to satisfy, like criteria. But I don't want to get into that because that's probably going to bore everybody, but that's more like for the lawyers. But yeah, if he proved that, if he got summary judgment already, that means that it's a good case. He's got that done. Okay, but good luck to you. I think that's a strong case. Okay, let's see what other questions we have. Let me go back to the comments section. Here's a comment. Oh, here's Here's another live question. I have you on my big screen. Okay, thank you. That's awesome. Is it good my case is going to a higher up in the litigation team? I have to meet with some of the main lawyers. Yeah, I mean, that's definitely a good sign. I mean, usually if you have a bigger firm, the way that I mean, different firms are organized in different ways. The way we're organized here is we do have litigation teams. So for example, like I'm on a team, I'm one of the senior attorneys. I have a junior attorney on my team. And then I also have one of the actually the chief operating officer of the firm is on my team too, kind of like the office manager. And so the three of us work together. And then we also have a paralegal that we can consult with, that you can help generate documents. Because, so the fact that you have, the higher ups, like the trial lawyers or the higher ups, your case is moving up there, that's good. Because if your case is being handled, let's say, some firms are organized differently, right? They might not have this team like we have. They might have just like, hey, look, a lot of the firms are more old school, right? So teams, I think, are more of a new thing that is good. I like teams because people collaborate, people share ideas, people learn. Like, right, if I know something, I could teach the younger associate on my team, and then the next case, the younger associate's going to know what they're doing much more, and they're going to do better. And I learn as well. Like, I have another attorney who's a trial attorney who's been trying cases since 1980. He's probably in his 60s. So sometimes we try a case together, the two of us, and I learn something from him, right? So it's always good to be learning and sharing and collaborating. But some firms, the more old school firms, the way they are organized is what they'll do is they'll just say, look, the partner wants to go play golf, right? The partner wants to, go on vacation. It doesn't want to do much work. They're the partner. They achieve the status, They'll just say, look, handle the case. They'll give it to some associate. The associate might be green. They might not know what they're doing. And then the partner might not supervise them as much as they should. So in that case, you might be in trouble because even though the law firm is prestigious, you have this associate, maybe like a few years out of law school, doesn't have much experience, doesn't know how to work up the case, and then they're handling the case. So the fact that they took that case away from them and moved it up to the higher ups, the people that are more like, say, the trial lawyers, the partners, that's a good sign. That's definitely a good sign. So good luck. Yeah, it should be a good case. Okay, let's see what other questions we have. Here's a question. It says, what information can I realistically expect from my attorneys? I was in an accident and the defendant is a multi-billion-dollar company. Will they tell me about the deposition and insurance policy? I got my foot degloved. I was in the hospital for a month, ICU for a week. It was in California. Yeah, I mean, definitely. I mean, your attorney really should be communicating with you, especially a case like that. If you had a degloving injury, that's when the skin is like a glove and the skin comes off. That's a really, really horrific injury, very terrible injury. So I'm very sorry to hear that. I hope you are recovering and feeling better, but that's just a horrific injury. So yeah, if an attorney is representing a client with that kind of injury, the attorney should be in communication with the client. And if it was like, let's say, a litigation team, like we were talking about, then perhaps somebody on the team, could be a junior associate, could be a paralegal, should be helping the client with simple things, right? Like the client needs a ride to their doctor, you get them an Uber, you get them transportation under the no-fault insurance policy, whatever things they need, simple things. If you need to do something simple, like, you just got the new case, you have to send a letter of representation to the insurance company. Well, the paralegal could draft that, the attorney could review it, it's a template letter, please be advised we represent John Smith, whatever it is, send it out. The lawyer is going to be like sort of going to trial, doing more like high level work, maybe reviewing the case, making sure the case is built correctly. The lawyer shouldn't be wasting their time, drafting the letter that you have 1,000 templates of, right? That's a waste of time, and it's a waste of. But I think that the lawyer should be communicating with you because the lawyer is the most knowledgeable on the team. So the team should meet once a week, let's say. They should all speak to each other. And if, let's say, the paralegal or the junior associate spoke with you, and then you said something that they couldn't answer, then they should ideally tell the lawyer, but the lawyer should also call you directly. But to answer your question, you're saying that, should they tell you about the insurance policy? Absolutely. I mean, they have to tell you the insurance policy. So if you're suing a multi-billion-dollar company, they should have a very large insurance policy. So you should be able to call the lawyer and just ask them, hey, what are the insurance limits? And the lawyer, if they're a good lawyer, if they're a trial lawyer, they should know that it's not just the primary policy, but it's also all the layers, right? The umbrella, the excess, supplemental, concurrent, all the policies. And they should dig deep and get that. And sometimes they'll say, not known at this time, or give you this kind of vague answer. And then in that case, you have to get the judge involved and get a court order and get those policies. And if they still don't give it to you, you can do affidavits of search. You can do affidavits of the insurance broker. You can do research from the insurance broker to find out, what are all the policies. And then the depositions, I think, if it's your deposition, the lawyer should be preparing you. Absolutely. I like to prepare the clients at least 3 times because people get nervous. People are just people, from every day, whatever their walk of life is, just normal everyday people. They get into a horrible life-changing accident like that. They don't know how to testify before a jury. They don't know how to answer questions. So, of course, you should definitely, speak with them. They should prepare you. The first prep is more like just an overview, explain how the deposition process works. They should answer your questions, get you calm, get you relaxed, things like that. You should actually talk to them. A lot of lawyers say in the first prep, the client should explain to the lawyer what they're worried about, right? And then the lawyer should answer their questions. Then in the second prep, they get into like the facts of how everything happened, the injury information, how it affected your life. You really got to do a deep dive about that, about your life and even like your biography, your friends, your coworkers. So yeah, absolutely. I mean, to answer your question, absolutely. I really think the lawyer should be communicating with you as much as possible. I always feel like the lawyer is the guide and the client is, being guided by the lawyer. That's why they say it's a counsel, right? To counsel someone is to give them advice, to help them. So that's very, very important. Okay. And then the person says, I've been speaking with my lawyers directly, but I don't get much direct information from them. I've been answering a lot of questions, just trying to be patient. Yeah, well, I mean, they should be answering your questions. You should be able to get, and the lawyers sometimes are busy, but they should make some time, especially a large case like that. They should make some time, carve out some time, answer your questions, just have a conversation, basically. It's important. It's important. Just like if you had a doctor, right? You were seeing the doctor, you'd want the doctor to speak with you, maybe not all the time, but if something important, the doctor's going to do a surgery, you'd want to have a consultation, you want the doctor to explain everything, what they're going to do, why they're going to do it, why it's needed. And, it's what's known as bedside manner, right? That's important. So the same thing with lawyers. Okay, let me see. Midwest Vibes says, I just got into an accident with a dump truck that I didn't collide with, but the rocks and gravel that were in the back of the dump truck were not covered up with a tarp. And I have a TBI, PCS, and more. Yeah, that could definitely be a strong case as well, because remember, negligence is just the failure to use reasonable care. Sometimes people call it ordinary care. So, I mean, if a dump truck is driving, let's say on the road or on the highway, and they know they have a lot of gravel and rocks and it's an open box in the back, they have to cover it up properly. They have to secure that load because obviously they could hit a pothole, right? There could be, somebody could stop short, they have to hit up the brakes. You don't want those rocks falling out of the dump truck, and then all of a sudden it's coming onto the roadway. There's pedestrians, there's bicyclists, somebody in a convertible, somebody on a motorcycle. People could get hurt, a passenger in a car. So that's a good case. That's an absolutely good case. And by the way, anybody that I'm talking with, if anybody has any more questions, if you'd like a consultation, just feel free to text me, the 347-566-9595. I promise to call a few people back later today. So if you're watching, I'm going to try to still do that. I'm going to try to call 1 or 2 of you today. And if I don't get to you today, then tomorrow. Thursdays and Fridays are good because it's a little bit more quiet. So I have more time, but I'm going to really make an effort. I'm going to, force myself, because I've been busy. I'm actually preparing for a case because I have a trial that I'm doing in May. So I'm preparing for that. Spent a lot of time on that. Yesterday, I talked with the surgeon. It was a fusion case. So the surgeon got on Zoom and we spent a lot of time prepping together. And there's another attorney that's working on the case with me from my office. So spending a lot of time on that, but I'm going to make time to speak with people as well because I want to help as many people as I can. Okay, let's see what other questions. And thank you for Mr. I see here, Harrier and Nate the Great, they gave some kind of contribution. Oh, thank you so much. Thank you. They said thank you to our channel. So thank you. I really appreciate that. And then Odd World says, hey, I have just got neck injections for my herniated disc from a commercial truck and trailer accident. And then it says something else about I have a Natasha. I'm not sure what that is, but yeah, I mean, neck injections can be serious, absolutely, because when you have the spine, the spinal cord, if you have a herniated disc, that's usually the type of treatment that they offer. The first type of treatment could be just seeing a chiropractor, doing adjustments, doing physical therapy. If that doesn't work, they might try the epidural steroid injections into the neck or into the lower back, and that's more of a pain relief. So the injection is a type of numbing. I believe it's like a lidocaine or a type of numbing agent, a steroid that will numb it to the point where you won't feel pain. But of course, that medicine's going to wear off. So if the medicine wears off and the pain comes back, then what you're going to need to do is probably a percutaneous discectomy, where they take a striker decompressor and it spins and the needle goes in and it actually suctions out part of the disc. It decompresses the disc. So then instead of the disc leaking, the disc will become a perfect circle again. And I think I've showed it before on some models. I can show it. Here's a model. Here you can see it. The red part is the herniation. So what they do is they go into the disc. This is the disc, and that's the vertebrae. The white is the bone. This is the disc. And so if there's a red part there, you see what they do is they just suction that red part out and it's gone. So that might be one of the options. But yeah, I mean that should be a good case. That should be a very strong case. And then I see the person says they actually have 4 herniated discs, and and a TBI. I see, a traumatic brain. Well, that's even bigger. A TBI, I think, is like the worst injury you could have, because the brain injury. I mean, a brain is really like who you are, right? Without a brain, we're nothing, right? Our brain is everything. It's basically consciousness, right? Understanding the way we see the world. So a brain injury is almost like it just changes who you are. And there's different types of brain injuries. Some parts of the brain control emotions. Some parts of the brain control things like executive functioning, memory, concentration, focus. And then, of course, with the emotional aspect, I did videos about this. There's post-traumatic stress disorder. So if the brain gets injured, then it could affect somebody emotionally, in the sense that they get angry really easily. They're not themselves anymore. It's almost like they become a different person. So that's a really serious injury. So I hope there's enough insurance there, because that could be a big case. Yeah. Oh, I think he said an 18-wheeler commercial truck hit him from behind, and after he drove away. Oh, he was a contractor for Amazon. Oh, wow, that's interesting. That's interesting. So yeah, that should be a big case, because Amazon's got a lot of insurance. So that's good. That, I mean, not good, but it's better than if he had less insurance. And I actually did a video recently, probably will be posted next week or the following week, a little bit about Amazon and these delivery service providers that work for Amazon, and the way that you could find out. Because sometimes what happens is you get hit by a truck, right? And then the truck, if you look at the police report, there's no indication that Amazon is involved. It'll just say, for example, Penske Truck Leasing. That's the leasing company. And it'll say some, like, I don't know, ABC Logistics, and that's the owner of the truck. And you won't know that Amazon is involved. The only way to find out is to get the cell phone records and to get the app on the cell phone, because they use this Amazon Relay. And then there's a whole system and procedure of how a driver can apply to become a delivery service provider for Amazon, whether they're driving those little Sprinter vans that you see, or they're driving their personal car, or they're driving a big tractor trailer. So I did a video about that. It probably is going to come out soon, so be on the lookout for that. But that's very interesting, the Amazon. And it's really, I heard that when Amazon entered the freight market, they took away over $2 billion from these other companies. I think one company in particular, I believe it was called C.H. Robinson, lost like $900 million that day, the day that Amazon came in. But the interesting thing is that the way Amazon does it, it's not very it's not very safe. The criteria for who could drive for them is pretty much wide open. Even if you are like unsafe, but as long as you're not super unsafe, you could still drive for Amazon. And even if you get an unsatisfactory rating, which is kind of hard to get, you have to be really bad to get an unsatisfactory rating. But even if you do get one, you could just like open up a new trucking company, and then even if you have no rating, you could drive for Amazon. So if you just opened up a company yesterday and you have no rating, and that's what people do. If they have an unsatisfactory rating, they'll just say, hey, Bob, let's open up a new company. They open up a new company, they have no rating, they can go drive for Amazon. So it's kind of crazy. That's the reality. Okay, let's see what other questions we have here. Tier Security asks, if I hire an attorney for personal injury case, then they hire another attorney to be the main counsel with the original counsel. Do I still pay 33% at settlement? Yeah, absolutely. You should still pay 33%. Now, if you hired an attorney and that attorney, for whatever reason, just feels that maybe they're not able to handle it, or maybe they need help, or maybe another attorney is more of a specialist, like it's a medical malpractice case, and this attorney is really good at this particular type of medical malpractice, like failure to diagnose a certain type of cancer. He's a specialist in that, right? So he co-counsels with them. That all comes out of the attorney's share. I like to explain to people, and by the way, this is a really common question. Like every time I do a consult, people ask me this. So the attorney's share is 30%. In some states, it's 40%, but in New York, it's 33%. So let's say that is the attorney's share. So that attorney and the co-counsel are going to share that 33%. And so you as the client get about 67%, right? 2/3, 66, 67%, maybe close to 70%, right? So that's the client share. They can't touch the client share. You could have one attorney, you could have 100 attorneys, 100 attorneys working on you, just your case. They still have to share that 33%. It's like a piece of the pie, right? You get the 70% piece, that's yours. The lawyers share the 30% piece, and that's theirs. Now, if you get 100 attorneys, they're all going to get a tiny, tiny little slice, but that's just the way it is, right? That's the legal share. They can't touch the client share, so you don't have to worry about that. Actually, I like it when attorneys work together and when they, collaborate. That's good sometimes. I mean, as long as, of course, you don't want to have too many attorneys, but like 1 or 2 attorneys, sometimes 3 attorneys work on a case. If it's a big case, that's a good thing. And people ask me that same question if they're thinking of changing attorneys, if they're not happy with their attorney and they're thinking about having me help them, either in New York, I could help them myself, or if it's in another state, I could recommend somebody, and I try to do a lot of due diligence, so the person I recommend is really, really good, one of the best attorneys. And then they ask me that question too. They're worried, right? What's going to happen to me? Am I going to get less money because I'm getting this new attorney? No. Remember, it's just you still get the 70%, the client share. The attorneys have to split that 30%, that 1/3 amongst themselves. So if you have the first attorney, they'll get the legal fee in proportion to the amount of work they did before you fired them, right? And then the new attorney will get the amount that he or she did from when you hired them up until when they resolve the case. Now, if they can't agree, if the 2 attorneys can't agree, then they go before the judge, and the judge looks at the work they did. They show the judge their files, they have hearings, they testify, just like a little trial. And then the judge will say, okay, you get 30%, you get 70%, or whatever, you get 50-50, but it doesn't really concern you. You still get the 70% client share. Okay, let's see, what other questions do we have? Okay, Real Talk Radio says, I was sexually assaulted by NYPD. How much is that case worth? I mean, I have to speak with you to see the extent, but the sexual assault cases can be worth a significant amount. I'm actually handling a bunch of those. I'm handling a lot of the Boy Scout cases, and those should be settling with the NYPD. In New York, we have 2 different statutes. We have the Child Victims Act, and we have the Adult Survivors Act. So I'm handling a few cases. I'm co-counseling together with another firm, a larger firm that's specializing in that, and they have a lot of attorneys that are dedicated to sexual assault cases. So if you need a consultation about that, just give me a call or send me a text at 347-566-9595. They are excellent. They're excellent attorneys. Because, yeah, we're seeing a lot of sexual abuse, especially with the prisons, in the prisons, but it could happen also like I'm sorry that happened to you with the NYPD as well. So that those could be very, very large multi-million dollar cases depending on the assault, depending on the after effects, the damages, but those are horrific cases. Okay. Let me see what other questions we have. Here's a question from Carlos. Hello, in your estimation, how much would a work injury involving an epidural shot, microdiscectomy, and spinal fusion would be worth? I mean, it's hard to say. Like, I know people want to know how much their case is worth. I understand. Like, if I had a case, hey, I want to know what's my case worth, right? Because that's like the ultimate question. But it's hard for me to really say just like from a few words. I'd really have to like look at the file, do more of a deep dive. But yeah, but in general, if it's a work injury where you're suing a third party and you have an epidural injection, I mean, just epidural injections I've settled for like 100,000, 150,000. You have a microdiscectomy. A microdiscectomy is serious. I would say a microdiscectomy could be worth 500,000 and up. And then a spinal fusion is very serious. That could be seven figures, meaning 1 million and up. So that's usually like a general range of each of the things you mentioned, what they're worth. That's what I would say. Okay. And then someone says the Florida County Clerk has been swamped with over 40,000 cases in 1 week because of the new law. Oh, I see, right. Probably the lawyers were trying to file all the cases in their office to get them grandfathered, right? So they knew the law was coming, so they wanted to get the cases filed because the law does not apply retroactively. It doesn't go backwards, right? So they didn't want to, because the new law is bad. I mean, the worst thing about it is that I think that comparative versus contributory, I did a video about that as well. If you're interested, you could take a look. But basically, comparative just means that whatever percentage the defendant is found at fault, you could still recover. So for example, if I get hit by a truck, but I did something wrong too, I was a bad driver, but they say the truck is 10% at fault, they give me $1 million, I could still get 100,000 because the truck was 10% at fault. But contributory means that if I don't prove the truck was 51% at fault, then I get nothing, right? So in that same example, if I even if I show that the truck was 49%, even if I show, if I show the truck was, even if I show that the truck was 50% at fault, right? Instead of getting 500,000, I get zero because I have to show the truck was 51% at fault. If I don't show that, I get nothing. So they changed the law in Florida. I think the insurance lobby is very strong, and they're changing that law in a lot of states. I know in California they actually changed it the other way because they had this crazy law from 1974 that put a cap on medical malpractice that you can't get more than 250,000 for non-economic damages. They raised that, and I know the attorney that worked to spearhead that, and they had a meeting with the governor, and they raised that limit. But then in other states, they're putting in those artificial limits. I don't really like those. I mean, I think that the jury should be able to decide, but unfortunately, right now, there's a lot of that happening politically. So, okay, and then let's see what other questions. Out of Sight says, "Hi, Mr. Frekhtman. Hello. Thank you for watching." God Mode says, "What if I had 2 back fusions and now the doctor wants to do a third one that will be a 3-level fusion?" Yeah, I mean, that just means that the case is worth more. Sometimes clients need to do more than one fusion. There's something known as adjacent segment disease. So for example, if you have a fusion at C4, C5, now that means that the C6 level is more likely to be more vulnerable, more delicate, more brittle, more likely to be vulnerable and be injured. And now you may need a surgery at the C6 level, the adjacent, the next level. So I don't know if it's because of that. It also could be because of sometimes, fusion. What a fusion really does is that they're taking out the disc. Like in that same example, this is the disc. They're taking out the disc, and then what they're doing is they're screwing in screws into the vertebrae here, and they're putting a plate to secure everything. But remember, this is your back. It's supposed to move. It's supposed to bend. So the fact that you have this plate, and then sometimes they put like allograft in there, or they take tissue from your hip, different types of, so it doesn't always heal properly. It doesn't always, so sometimes you do need another surgery. And I think that just makes the damages higher because now you have 3 surgeries. Absolutely. And then Oddworld says, what would you happen to know how much my case is worth? I also have prism glasses because of my double vision. I mean, yeah, like with that, that's a serious case. I mean, if you have a traumatic brain injury, it's a serious case. It's hard for me to say how much it's worth here, just from like a few words. I know you were hit by the commercial truck and you got hit from the back, so it seems like the liability is not an issue. And the contractor for Amazon should have unlimited insurance. So I'd have to speak to you though. Just text me the 347-566-9595 either tomorrow, or if not, the next week for sure. I'm gonna make office hours, just like maybe in the afternoon. So I'm a morning person. I wake up early. I wake up like 6, 7 in the morning. I'll go to the gym. I'll do a little while I go to the gym. I'll listen to something like a continuing legal education, maybe like a podcast or something interesting, or maybe an audiobook, something to improve myself while I'm working out. And I'll listen to something. And then, I get to the office and try to do my work. And there's a lot of different types of work that I have to do, right? There's like marketing, there's obviously working on cases, there's a little bit of supervision, making sure other people are doing what they're supposed to do. We have about close to 25 people in our firm. So, but by the end of the day, by like this kind of time, well, now it's 6:22 here in New York, but when it gets a little bit later, I get a little bit more tired. I guess like everybody, so I got to take a break, and maybe, to take a break from the work, take a break from reading, and make some calls, speak to some people, help some people. So I'm going to do that. I'm going to just put it in my schedule and just do it, So, and I enjoy that. I enjoy helping people. Okay, let me see. What other questions do we have? Maybe I'll do like one more question and then I'll have to run because I think we're almost we're at the 42-minute mark already. Wow. So that's good. We have a lot of people interested, a lot of people watching, a lot of questions. And I thank you for that. I'm very grateful that people are watching our channel. And by the way, the other thing that I really ask of everyone is let me know what videos you want to see next, because what I'm going to start doing also is I'm going to start making like a content calendar, because like sometimes I'm just like reading the newspaper or I see something on social media, like on Instagram or on Facebook, and I'm like, wow, that would be a great topic for a YouTube video, and then I'll save it somehow and maybe I'll come back to it. But I think it's a great idea to just get the audience involved and have you tell me what you want to hear about, and then I could do videos. Like this week, I happened to watch Continuing Legal Education by this other attorney, and it's actually funny because I actually have a case with him. We're working on a case together, also a trucking accident, and he was talking about Amazon and the way that he found out that it was Amazon, even though there was no indication of Amazon. Like any other attorney, if they wouldn't have gotten that app on that cell phone of the driver, they would have never known that it's Amazon. And then if you don't know it's Amazon, then obviously you're losing out on millions and millions of insurance. If it wasn't Amazon, the insurance would have been probably 750,000 total, but with Amazon, it could be like 10 million, 20, whatever, unlimited. So it's a huge difference. Yeah, so absolutely. Okay, let me see what other questions we have here. Okay, Mike Richards says, hello, Attorney Frekhtman. I am grateful for your help and knowledge. Thank you so much. He says, question, does the value of a TBI case drastically increase when there is brain bleeding and memory loss? Yeah, absolutely. I mean, the more serious the TBI case is, the more value. So basically, if you have an MTBI, meaning a mild traumatic brain injury, now I don't like the phrasing mild because it's kind of like a misnomer. You could still have a brain injury, it's brain damage. It could still be serious. But sometimes it could be mild in the sense that the person has some cognitive deficits, but they're pretty much okay. They can go back to work, and some people may not even know that they have a brain injury. They're still entitled to some kind of compensation. for example, like post-concussive syndrome. And then after a concussion, sometimes it gets better and the brain gets better and people feel better. Sometimes the concussion is the traumatic brain injury and it's going to be permanent. But if you have something like brain bleeding, that's very serious. If you have memory loss and it's confirmed, that's very serious. And usually that's permanent, unfortunately. So that's definitely going to increase the value substantially. And somebody says, thanks for the stream. Thank you. Thank you for watching. And then Midwest Vibe says, what's your number again? Yeah, sure. So the number is just, it's 347-566-9595. And I think it should be in the description as well in the video. I could drop it in the chat as well. I'll drop it in the chat, yeah, so people can reach out to me. Yeah, I'm happy to help. Actually, this week I found out one of the people I helped, I think in the state of Georgia, they needed an attorney, and I had referred excellent attorney in Georgia, and that attorney actually helped them with their case. It was somebody from our YouTube audience, and they ended up getting close to $2 million. So I was really happy that I was able to help them. So that's what it's all about. My goal is helping serious injury victims and their families. So I was really glad that I was able to help that person. And let me see, B Oracle says, how do you deal with a defense attorney that is very unresponsive? I have a case with a rental car company that has been going on for 4 years. Well, I mean, the defense attorney has to be responsive in the sense that, when you go to the preliminary conference order, the judge will say depositions by a certain date. Like, for example, if I was to go to a preliminary conference order today, the judge will issue an order. You'd say depositions by May 30th, right? Compliance conference June 15th, and then certify the case as trial ready by like August 1st. So if we come June 15th, and then the first thing the judge will say was, well, have you complied with my order? Because it's a compliance conference. We're here to see, have you complied with the court order? And remember, a court order is not an invitation to a cocktail party where you can say, I don't want to go. It's a court order. You have to follow it. So if you say no, the judge is going to be upset. And then they're going to say, okay, I'll give you an extension. Now do depositions by August 1st and certify it by October. But if you don't comply a second time, and then meanwhile, you can write a good faith letter. Your attorney should write a good faith letter to that defense attorney that's being unresponsive. I don't know what they're being unresponsive about. But for example, if they're not willing to hold depositions, if they're asking for authorizations, like to get your medical records, your attorney has to provide that to them. But if they're refusing to hold depositions, I would make a motion. And in New York, we make a motion to strike their answer, which means that their answer is like their appearance in the case. If that gets stricken, then it's just an inquest, right? Then it's just damages only. It's almost like a default judgment. They're gone, right? It's almost like they don't exist, and you get a default. Judges don't like to do that. They like to decide cases on the merits. What they will do is they'll issue an order to compel them to show up and to give that, to take the deposition of the plaintiff and to produce their witness. And sometimes they'll do like conditional preclusion. If they've really violated the order 2 or 3 or 4 times, the judge will say, you know what? You violated the order so many times. What you have to do is you have to produce your client and you have to do these depositions by, let's say, August 1st. And if you don't, you are precluded, meaning you can't do it. And then if the case goes to trial, you can't even show up. Those witnesses can't come to court. So that could be powerful. Okay, everyone, I hope this has been helpful. Thank you so much. I think this was a great last week tonight, and we'll keep doing these. I'll do a few more that are recorded if you leave comments and questions in the chat. I just ask that you leave some information about the facts, what happened, as well as the injuries, and as well as your question. And I'll do some more of these lives too. I like doing it. I like doing it live. It's a little bit more interaction. It's a little bit more fun. The recordings are good too, but the live seems to have a little bit more energy. So I like that. I appreciate that. So please like and subscribe to our channel. Let us know what questions you have, and we are here for you. Okay, everyone. Have a great night, and thank you.